night on the CINA 102.3 app at cinafm.com, on TuneIn, on smart speaker, and at 102.3 FM. Cina Radio, every device, everywhere. The following program does not necessarily reflect the opinions of the management, staff, or advertisers of Cina Radio.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. مرة أخرى على الموقع الإلكتروني yourrights.com/radio أو على اليوتيوب. كل ما عليكم هو البحث عن قناة جومانا كيروز، وحلقة جديدة اليوم، وموضوع الحلقة عن البانكربسي مع المحامي مايكل بانكستين. مساء الخير وصباح الخير، أهلا وسهلا فيك جومانا في راديو سينا.
صباح الخير مرامي، صباح الخير لكل المستمعين، صباح الخير للمحامي مايكل بانكستين. نهار جميل، الشمس ساطعة وطالعة، وأخيرا بفتكر الأسبوع القادم منبلش السبرينج.
صح، الساندي راح نغير التوقيت، راح يكون التوقيت الصيفي، وأخيرا يعني الحمد لله.
وأيمت أول نهار ربيع؟
يعني مبدئيا هو تغير الوقت، يعني المفروض يبلش الربيع next week أعتقد.
أوكي.
على الأكثر يعني.
very good.
يعني hopefully تكون الأجواء شوي أحسن من last week.
إن شاء الله يا رب، لأنه ما شفنا الشمس بتاتا هالشتوية. قبل كل شيء بدي وجه happy birthday لبنوت أمورة جميلة رائعة، أبوها رائع، اسمها مايا من وينزر. ما بعرف إذا عم تتسمع لأنه بتكون بالمدرسة. بدي وجه لها happy birthday، وإلا إنه هي she is an inspiration. البنوت مرقت بظروف كتير صعبة، بسرطان ظهرت منه. ما بقدر خبرك عن إيمانها، ما بقدر خبرك عن قوتها، ما بقدر خبرك عن حكمتها. بدي إلا إنه إن شاء الله يا رب إنه المرق عليكي ما بقى يمرق ولا عليكي ولا على حدا. وبدي أتمنى لها a wonderful 16th happy birthday لمايا. happy birthday مايا، إن شاء الله يا رب يكون الوالد عم يتسمع من وينزر
إن شاء الله.
واليوم انتقالا نحن لمدة ساعة عن الله راد عم نحكي عن قضايا البانكربسي، قضايا الإفلاس. بنتمنى لو الاتصالات أو التعليقات بتكون فقط عن موضوع البانكربسي، فقط عن موضوع الإفلاس. أرقام الاتصال هي 313 على الاستوديو 769-6666، ومن وينزر 519-256-1023. Welcome, Attorney Michael Bangstein.
Marhaba, Joumana. How are you doing today?
I am good. How are you doing?
Excellent, thank you.
It is a beautiful day today.
I love it. Spring is coming.
Spring is coming. Spring is around the corner, and I understand from Rami that the clock is shifting on Sunday, correct? Do you know when is the first day of spring, Michael?
Generally, it seems like it's about the 21st every 3 months. So I think it's about the March 21st.
March 21st. Okay,
give or take a day.
Give or take. It is around the corner. Very good. I want to begin by talking to you about fraudulent transfers, about preferences, and about payments to insiders.
Great.
All right. And so I want to pose to you the following scenario. I am risking bankruptcy. I think I have to file for bankruptcy. I have a home and I want to deed it to my daughter, or I have money in the bank. I want to pay off my cousin, or I have a business. I want to transfer it to somebody else, and I then file for bankruptcy. Am I violating the law?
Well, there's 3 things that are very related to each other. You have preferences to creditors, you have payments to insiders, and you have fraudulent transfers. I'll start with the fraudulent transfer because that's the first thing that I kind
So
of...
is transferring my home, the title of my home to my daughter, considered a fraudulent transfer?
There doesn't need to be any fraudulent intent, but if you transferred the real estate to somebody within the last 6 years for less than market value, it'll be regarded as a fraudulent transfer, even if there was no fraudulent intent.
Okay, and even if I did this even if I transferred something to my daughter or to my friend or to my relative, if I transferred the title and I did not mean to defraud the government and my creditors, and I didn't even know at the time I transferred the home that I may be going through bankruptcy, it's still considered, if it was done in the past 6 years from when I end up filing bankruptcy, it is still considered in the eyes of bankruptcy law fraudulent, although by definition, fraud requires intent.
Yeah, in the fraudulent transfer statute for bankruptcy, it does not require fraudulent intent. Now, clearly, if there was fraudulent intent, then it's a fraudulent transfer. But there doesn't need to be a showing that there was fraudulent intent. If it was transferred for less than market value, that'll be caught by that statute.
Okay, so even if I gift, my daughter gets married, and I gift her, and I have every right as a parent to gift her a home. I give it to her as a gift. I buy her a home, and I give it to her as a gift. She does not pay any money. 5 years later, at the time I gifted my daughter anything, I was miles away from thinking that I will be filing bankruptcy. 5 years later, I file bankruptcy. Is this considered a fraudulent conveyance within the meaning of fraudulent conveyances?
It is, because it was a transfer
Yes,
of
it is.
property within the last 6 years for less than market value. But what I would say is, I like that you mentioned 5 years ago, because what I would say in a case like that is, okay, the look back period is only 6 years. So let's put together some strategies, some plan of action to sort of keep the creditors at bay until another year and a day has gone by, so that we're out a few days past 6 years, and then that's totally fine.
Okay, so, and you're speaking very fast today, by the way.
I will slow down.
You may want to slow down just a tad. So, to the extent that you can delay the filing of bankruptcy so that the gift to your daughter is now older than 6 years and 1 day, you are safe.
That's correct, because the look back period on that kind of transfer is only 6 years.
Okay, and that's because I gifted it to her, but the market value of that home may have been $100,000, but I gave it as a gift. Correct?
That's right.
Okay. What about the scenario when people know that they are filing for bankruptcy and they owe cousin Vinny $1,000 and they owe credit card A $1,000 and they want to keep credit card A. And so they proceed to pay off cousin Vinny. They pay off the credit card because they know after the bankruptcy they will need that credit card so that they can continue to survive. And then they file for bankruptcy. What happens to the payment? Was I wrong? Did I violate the law in paying off cousin Vinny before filing bankruptcy? Cousin Vinny owes me money and I don't want him. There is a bond between me and cousin Vinny, and I don't want to look bad, and I want to make him whole. I want to give him back the money. Did I make it? Is that what you call a preference or a payment to an insider?
Well, there's preference is a little bit different. We'll talk about that with the...
Let's talk about cousin Vinny.
Yes,
is
that's
that a
a
payment,
payment
to
an
an
insider, yes.
Okay,
So
payment to an insider.
If you make
and does the law say that you cannot do that?
The law says that when you're going to file bankruptcy, at the time that you file the bankruptcy, if within the year before you file for bankruptcy, you've made a payment to a family member, that's someone that you're related to by blood or marriage, then that is a payment to an insider.
So an insider is defined as someone who is related to you by blood or marriage.
That's correct.
And you are looking only 1 year back because it's a payment of money versus you are looking 6 years back if it is conveying a title.
Yes.
Okay, so a title, you look 6 years back. Money, you look 1 year back. So I can pay Cousin Vinny today and file for bankruptcy in 1 year and 1 day.
That's correct.
And an insider, that's called a payment to an insider.
Yes.
It is someone who is related to me by blood or marriage. What about the second part of my question? I want to pay off my credit card because I know once I file bankruptcy, I will need that credit card. Have I violated the law?
I'm just going to throw in one more thing about Cousin Vinny.
Yes.
It's not what you owe, it's what you've paid. So if you owe Cousin Vinny $1,000, you don't have to wait so long as you don't pay him the $1,000. And I know that Cousin Vinny is thinking, hey, where's my money? Where's my money? I know you're about to file for bankruptcy. You can tell Cousin Vinny, I've talked to a bankruptcy attorney, and if I pay you right now, the trustee's going to come after you for that $1,000. But if, for example, I'm filing a Chapter 7, that's only a 6-month process, file the bankruptcy, complete the bankruptcy, get rid of your debt. The day after, you're no longer under the jurisdiction of the bankruptcy court. Here you go, Cousin Vinny. Here's your $1,000.
So you will not list Cousin Vinny on your schedule as a debtor?
Well, if you owe money,
as a creditor?
If you owe someone money, if you believe that somebody has a legally...
Let me make sure I understand. This is very important. What if I want to exclude Cousin Vinny and I don't want to list him on the schedule? Do I have a legal duty to list each and every one of my creditors that I can remember on the schedule?
Here's how I view it. The bankruptcy code says that you have to list everyone that you owe money to. But I also kind of read that together with the state laws on, when you're collecting, when you're suing to collect. When you file a complaint, one of the things you have to attach is some kind of proof of the debt owed. So if there's nothing in writing, it's questionable to me whether or not that's a legally enforceable agreement.
Okay, your point here is that often between family relatives, you're not giving money pursuant to a written contract. You just went and asked your cousin for money and he gave it to you. So there is no, versus a car note versus a credit card, it's all in writing. So it's not clear because it's not in writing.
Right.
Okay.
I mean, what if the worst happened and you said, I'm never going to pay you back, Cousin Vinny. I'm not filing for bankruptcy, but I'm never paying you back. How would that be legally enforceable? How would he ever prove that in court?
Well, I mean, an oral contract is a contract. The problem is trying to prove the four corners of that contract. Yeah. He said, you say, I borrowed 1,000. He goes, no, I lent him 1,500. And you say, I borrowed it over 5 years. And he says, no, I gave it only for 6 months. And right. An oral contract is a contract. The problem is trying to convince a jury or a judge what the terms of that contract were when it's not in writing. That's why we always advise people in their agreements with others to put it in writing, because then it's clear what the terms of the agreement are.
Exactly. So when you file a complaint for what's known as account stated, saying, hey, I lent someone some money, they've got the money, you have to attach to the complaint right away when you're filing in court proof of the debt owed. I mean, how would you even get past the complaint stage?
Okay, so going back very quickly, we have a number of callers waiting. Going back to a payment to an insider, such as a relative by blood or by marriage, if you give that money within 1 year of filing, then the bankruptcy trustee is going to take it back.
Yes.
But you gave it to me and I spent it. How can the bankruptcy trustee go after me?
The trustee doesn't care if he or she gets it from Cousin Vinny or from you, but they are going to want the $1,000.
So it's going to be listed on the person who's filing bankruptcy as money they still have.
You may have
Kinda.
to, if you don't have the money, you may have to work out a payment plan
But
with the
what I'm
trustee.
saying is correct, is that although I'm filing for bankruptcy and I have given the $1,000 to Cousin Vinny, the bankruptcy trustee is going to consider as if I still have $1,000 in the bank.
Yes, they have avoidance powers to undo that transaction.
Okay, understood. So it's going to make it harder for me to go through bankruptcy because I have a credit of $1,000, although I've given that money to Cousin Vinny. What about, very quickly before we take our first caller, what about payment to a credit card company in anticipation of filing for bankruptcy?
The bankruptcy code
What
says,
is that called? Is that called a fraudulent transfer, a payment to an insider? No.
That's a preference. It's
That's
a preferential payment.
Preferential payment,
Yeah.
meaning
You can't
I
prefer.
owe money to a lot of people. I am singling out one entity or one person over the others, and then I file for bankruptcy.
Yes, you can't. In bankruptcy, you cannot prefer one creditor over another.
Okay, so it's a preferential payment
That's correct.
to a creditor. And the credit card company was very happy to take my payment.
Oh, they'll take your money. Yes.
Okay, so what happens then?
What happens is, here's what the thinking goes. The thinking goes, well, I've got $1,000 that I owe to a credit card X. I want to keep credit card X. So if I pay them $1,000, now they've got a zero balance. If they've got a zero balance, they're not really a creditor. I don't have to list them, and then they aren't going to close the card. The only problem with
They
that,
will close the card because they're
that's-
going to find out
well,
about your bankruptcy.
I'm telling you what the thinking,
What
the
people
thinking
think
is. Yeah.
is.
So what happens is you call up the credit card company and you pay them the $1,000. They'll take your money. You'll have the zero balance. If you don't list them on the bankruptcy because you don't
You don't owe them
you don't
money
owe them
anymore.
anything. But credit card companies pull your credit report fairly regularly, and they're going to see that you have a bankruptcy, and they're almost certainly going to close that card.
Okay, so first thing we want to say is, and by the way, is there a 1-year look-back rule?
No, the standard for preferential payments is if you've paid any one creditor $600 or more over the 90 days before you file for bankruptcy.
Over 90 days or less.
Yes,
So if I have paid them 91 days ago, I'm okay.
yes.
Okay.
Well, you're
so
okay either way.
$600 or more.
You're okay either way because the trustee isn't going after you for the money. They're going after their credit card company for the money.
So what does that mean? Is the credit card company going to repay the bankruptcy trustee the money paid by me?
They'll have to because the bankruptcy trustee appointed by the court has avoidance powers to undo that transaction as well.
So they will not go after Cousin Vinny to repay the $1,000, but they will go after the credit card company to repay the $1,000.
They may go after Cousin Vinny. More likely, they're going to want the $1,000 from you that you paid Cousin Vinny.
Right.
But it's not impossible that they may ask Cousin Vinny some questions.
So when you have more than one creditor, example, a credit card company, a mortgage, a car payment, and you decide to pay off one so that they're no longer a creditor, and then file for bankruptcy, if you have paid them more than $600 within the last 90 days of filing bankruptcy, in all likelihood, once you file bankruptcy, the bankruptcy trustee is going to go after that creditor and get the money back. How will the bankruptcy trustee know about the existence of the credit card company since I did not list it as a creditor on the schedule?
Well, you can see the trustee has powers they has subpoena power. They have access to all sorts of databases. They're going to get the last 2 years of your tax returns. They're going to get at least 3 months of your bank statements, possibly 6. They have numerous powers available to be able to investigate the matter. And this is really important for you to know. Well, why does the trustee care? Because whether it's a payment to an insider, whether it's a preferential payment to a creditor, whether it's a fraudulent transfer, the trustee gets 25% of what they recover. That's the trustees' buy-in. That's why they're very closely supervising this. That's how they really make their money.
25% of what?
25% of what they discover and recover. So if, hey, it's $1,000 that you paid cousin Vinny, I need you to pay $1,000.
I will tell you that every lawyer I have met who is a bankruptcy trustee is a very wealthy, prominent lawyer. And it's because when they are involved in those bankruptcies, whether it's because of volume or whether because it is a particularly high-end person files for bankruptcy, they get to get 25% of the money that they recover.
Yes, that's their buy-in. That's their motivation. That's why they care.
Okay. So it is a waste of time for anyone who thinks that she or he will be filing bankruptcy to transfer any piece of real estate within 6 years or gift any piece of real estate within 6 years. It is a waste of time to pay anyone related to you by blood or marriage within 1 year of filing bankruptcy. It is a waste of time to give preferences to one over another if you're paying them more than $600. And we're not talking about anybody related to you. We're talking about a creditor, like a credit card company, a landlord, a car payment bank company. If you prefer one of these over the other and you've paid them $600 or more within the last 90 days, in essence, you are wasting your time because the bankruptcy trustee is going to consider it as a credit on you, or will go after the creditor and get that money back. She or he, the trustee, may or may not go after your cousin, but it's going to be in your column of money you have. So either way, it's a futile effort. It is a waste of time. And like attorney Michael Bankstein said, for something to be called a fraudulent conveyance, it does not to be fraudulent in the real sense of the term. If we open the dictionary to, read the definition of fraud, I am sure somewhere in there it says an intent to. There is, meaning you know what you're doing and you're doing it anyhow. It's not that you violated the law. It's not that you did something wrong. It's that you knew and you did it. There was intent. It was not an error. It was not negligence. It was not by mistake. It was intentional. Well, within bankruptcy laws, you don't need the intent to defraud. A parent totally can gift their child or their sister or their brother a home without intent to defraud anybody, without thinking that 5.5 years down the road they will be filing for bankruptcy. Well, in the eyes of the law, that's considered a fraudulent conveyance. We are talking today with attorney Michael Bankstein, who heads the bankruptcy department in our office and who is extremely busy lately because of the new billboards and the new advertisement that we have put up about our fees in Chapter 7 bankruptcy. And we'll talk about those very quickly. We remind, and we know some people have been very patient waiting. Give us a couple of minutes and we'll take your call. We have 30 minutes remaining. The numbers to call are 313-769-6666 and 519-256-1023. What are our fees in a Chapter 7 bankruptcy? Now, this is a bit of advertisement on our part. Go ahead.
The attorney fees for a Chapter 7 bankruptcy in our office is $575.
Okay. And then in addition to that, there is the court fee that you pay to the court unless we can convince the court to waive it. And we talked about the federal poverty guidelines. And if you make less than so much, then we can ask the judge to waive the $335 that you would normally pay to the court. And then there is the credit counseling and the credit report. About $420 in cost, correct?
Yeah, it works out to about $420.
Okay. Thank you very much, attorney Michael Bankstein.
Thank you.
And we will take our first caller. Hello? Hello? I think that our caller has been waiting so long that she or he got tired of waiting. Again, anyone who wants to call and ask or comment about bankruptcy, we had a lot of callers earlier, and I think we made them wait so long that they got tired. Please call The number is 313-769-6666, 519-256-1023. I don't have the sheet on me, or maybe I do. People who can succeed in getting their cost, the $335 waived, are people who must be within 150% of the poverty guideline. For a family of two, do you have those numbers on you?
I do.
Okay, for a family of two, what is that? How much money need they make less than, so that we can convince the court to waive? Thank you. I will read them quickly because we don't want to lose our caller. So for a household of one, if you make less than $18,735,000, we can convince the court to waive your $335 fee. And we can convince the court to waive that fee. And I'm going to read them quickly. If you are a family of two, if you make less than $25,000, $365,000 a year. If you are a family of three, if you make less than $31,995. For a family of four, if you make less than $38,625. Family of five, if you make less than $45,255. Family of six, if you make less than $51,885. Family of seven, if you make less than $58,515. And a family of eight, and we'll stop there, if you make less than $65,145 in income annually. And Rami, we can take our first caller. Hello.
Yeah, hi, Joumana. Hello, hi, Joumana. How are you?
Very good. And who are we speaking with?
My name is Sarah.
Hello, Sarah.
My question is about if I need to file bankruptcy and I do have a safe deposit box on the bank.
Okay.
How does that work?
Okay. So Sarah is considering filing for bankruptcy and does have a safety deposit box opened in a bank.
Yes.
Okay.
Hi, Sarah.
Hi.
It's totally fine to have a safe deposit box. One of the forms that you have to fill out in the bankruptcy and file to the court is known as your Statement of Financial Affairs. One of the questions in the Statement of Financial Affairs is, do you have a safe deposit box or a safe? And have you had a safe deposit box or a safe within the last year? So you would have to disclose that you have a safe deposit box. You'd also have to list what the contents of the safe deposit box are. So whatever the contents are, that's property that we would also have to exempt or protect in the bankruptcy.
Okay, so Sarah, if you have $10,000 stashed, I assume, in a safety deposit box, and when you file for bankruptcy and you fill out what's called the Statement of Financial Affairs, one of the questions is whether within the past 1 year you have had or you maintain a safety deposit box. You have to list its contents. So, you're signing this under penalty of perjury. You must state that you have $10,000 in your safety deposit box, correct?
That's correct.
That's correct.
And it's safe in that case because you have something which is known as a wild card exemption, where you can protect up to $13,100 worth of that kind of item. So if you had $10,000, the way to keep it safe is to disclose it, shine a light on it, and put the exemption on it so that you can keep that $10,000.
Okay, so let's break that down again, because this is a first for me. If you have a safety deposit box that has money in it, whether it's cash or whether it is maybe a diamond ring, let's say, you would
Yes.
put it in a safety deposit box and maybe the value of it is $40,000. You can protect the first $13,100.
If it's cash, there's also a jewelry
cash.
exemption. There's a jewelry exemption that you can use too.
Okay, and what is the jewelry exemption?
The jewelry exemption is $1,600.
Okay.
Now, let's say that the jewelry is worth $2,000. It isn't that the jewelry isn't safe. You use the $1,600 for the jewelry exemption, and that other exemption I talked about, the reason it's called wild card is you can break different pieces off and put them on different types of property. So if you're $400 short on the jewelry exemption, you can use the jewelry exemption plus $400 of your wild card exemption, and then that $2,000 piece of jewelry is perfectly safe. That's the way to keep it safe.
Okay, I think it got a little bit complicated. I think if we can summarize it, because
Sure.
again, we give general information. you have to disclose in the statement of financial affairs when you file for bankruptcy. And we thank you, Sarah, for calling on this, because I can tell you I have not heard that before, and I know no other caller therefore has brought that to our attention. So under the statement of financial affairs, you have to disclose what's in it. Part of, I'm sure, what's in it are important documents for you, maybe travel documents, maybe birth certificates and stuff like that. But I think that the bankruptcy. But I think the bankruptcy court is more interested in what's of value. That could be cash and or jewelry, right?
That's correct.
If you have cash up to $13,100, it's protected. And if you have jewelry, the first $1,600 is protected. And the cash, is that what's called the wild card exemption, or is that whole thing called the wild card exemption?
It's called the wild card exemption. You can use it for cash. You can use it if you've gone over your exemptions in another area.
Okay.
You can use it for, tax refunds, different things. That's why it's called wild card, is you can spread it out where you need to.
Sarah, do you care to share with us some of what's in your safe?
What is that?
Would you like to tell us what is inside your safe deposit box?
Okay. I do have my dad. He's old-fashioned,
Yes.
and he got to America. He's a new on America.
Yeah.
He don't want to leave any papers on the house.
Yes. So that's
I open a box.
that's not
for him.
old-fashioned. That's smart.
Okay, and he do have a ring diamond.
But that is not
So
yours. It is his.
It's his, yes.
Okay.
And the box is under my name and my niece's name. It's not only under my name.
Okay.
So that's why I want some information about if I have
So,
save box on the
so
bank.
Attorney
how it's
Michael
gonna work.
Bankstein, 2 questions quickly before we take our callers. We don't want to make them wait too long. Number 1, the ring is for Dad. That's not a problem.
You have to list what's
Okay.
inside the safe deposit box, but again, if it's not yours, then you don't have to worry about protecting the ring because it's Dad's ring.
You're holding it in trust for somebody else. What about the fact that the safety deposit box is open in her name and her niece's, but she and only she will file for bankruptcy, not her niece? Is her niece is in danger in any way?
No, she's not. I mean, you have to list to the bankruptcy court who has access to the box, but your sister
But
is
it's not
in
relevant.
bankruptcy.
She's not in
It doesn't
danger.
hurt her, but the court has to know who she is and who has access to the box.
Yeah, for sure.
Thank you, Sarah. Thank you for calling.
No, thank you. Thank you.
Thank you so much,
With
Sarah.
our pleasure. Thank you for introducing us to the wild card exemption, which is about, in part, safety deposit boxes and what happens if you file bankruptcy and you have a safety deposit box that may have cash and or other valuable items. We take our next caller. Hello.
الو مرحبا.
يا أهلا وسهلا. مع مين
الله
عم
يخليك.
نحكي؟
مع عطية.
يا أهلا أستاذ عطية.
بس سؤال، أنا بسمعك وكل شيء بس مش عارف أفهم إيه الفرق بين chapter 7 و chapter 11.
هو chapter 11 ولا chapter 13؟
هي بسمعها كل مرة وبتلخبط، مش عارف ده إيه وده لويه.
أستاذ عطية، من الأسئلة some of the frequently asked questions is what's the difference between chapter 7 and 13 مش 11، لأنه كتير عالم بيتصلوا بالمكتب وكتير عالم بيسألوا هيدا السؤال، فصدقني حضرتك منك الوحيد اللي ما بتعرف الفرق، والفرق مش كتير هين الواحد يفهمه. هي رح اطلب منه للمحامي يجاوب، بس تأختصر لك هي حسب شو قديش عندك، قديه عندك اشياء لك انت، قديه شو قيمة البيت تبعك، قديه في عندك equity ببيتك الى اخره. بس رح اطلب من المحامي المختص بالموضوع انه يجاوب، ورح ارجع ترجمها بالعربي. Attorney Michael Bankstein, Mr. Atiyah is calling and saying, I listened to you guys and I am still not sure what's the difference between chapter 7 and he called it chapter 11.
Marhaba, Mr. Atiyah.
First of all, we've never talked about chapter 11.
We haven't. When people say chapter 11 in the consumer context, they almost invariably, they're referring to it chapter 13.
Okay, very quickly, before we answer Mr. Atiyah's question, what is chapter 11 in 30 seconds or less?
Chapter 11 is for like a business, like, Sears is filing for bankruptcy.
So استاذ عطية, Chapter 11 هي مش للأشخاص, هي للشركات. So حضرتك بتعني الفرق بين Chapter 7 and Chapter 13. If you can give us, go ahead.
Or there's also, sometimes you'll hear like a musician or an actor, the Johnny Depps of the world who make $46 million a year, but God bless them, they manage to spend $50 million a year. So if you have a really high net worth, sometimes you have to do a Chapter 11, but 99% of consumers are Chapter 7 or Chapter 13.
اوكي, عم بضيف انه Chapter 11 هي للمؤسسات او الشركات, وهي للاشخاص اللي مدخولهم مرتفع جدا جدا جدا, بس بصرفهم اكثر من مدخولهم. فعطى هون اكزامبل عن ممثل عمل 48 مليون دولار بس صرف 50 مليون دولار, هيدا الشخص بيعمل Chapter 11. Chapter 11 هي منا للأشخاص اللي بيعملوا 50,000 و100,000 و200,000 ونص مليون دولار بالسنة. Chapter 13 هي اللي بتطبق. What's the difference? If you can start before giving the details, if you can give them a big determining factor in what decides first as to Chapter 7 and 13, and then you can give the specifics.
A major dividing line is, do you have the ability to repay your debts over time, or do you have little to no ability to repay your debts over time? That's one of the fundamental things I look at.
اوكي, سو من الاشياء الاساسيه اللي بننظر لها وقت اللي بيجتمع هو مع موكل عم بيفكر يقدم تشابتر بانكربسي ليعرف اذا مؤهل هيدا الشخص لتشابتر 7 ولا تشابتر 13. السؤال الاساسي هو, هل عندك القدره تدفع ديوناتك بالمستقبل؟ اذا عندك القدره, هو السؤال اللي بيحدد الفرق بين Chapter 7 و Chapter 13 من الأسئلة الأساسية. إذا في القدرة موجودة للإنسان يرجع يدفع ديوناته بالمستقبل بالتقسيط, that person would be entitled to Chapter 13, correct?
Yes, if someone has $50 left at the end of the month, that's a very different proposition from $500 left at the end of the month.
Okay, so what else can we tell the listeners who are wondering, do I qualify for Chapter 7 or do I qualify for Chapter 13 bankruptcy?
Part of it is if you're current on things like a car note or a mortgage, or if you're behind. If you're 4 months behind on a mortgage and you're facing foreclosure, the filing of a Chapter 7 would stop the foreclosure sale in some temporary manner, but your creditor would be able to say, hey, court, we want you to lift the bankruptcy stay so that we can still foreclose, because a Chapter 7 doesn't repay any debts. Chapter 13 would be a better fit if you're behind on your mortgage, for example.
Okay, so Chapter 13, if for those who are listening who are more than 4 months behind on their mortgage.
Well, that was just an example. Yeah.
For example, it's more likely that they should file Chapter 13 than Chapter 7. Would the filing of Chapter 13 stop the foreclosure from happening?
Yes.
Okay.
Yes.
So Chapter 7 and Chapter 13, both in the short run, will stop the foreclosure from taking place.
That's correct.
Okay. And in this office, we have been able to help a number of clients who came to us literally a day before the foreclosure of their home was going to take place. And we filed emergently Chapter 7 or 13 and were able to stop the foreclosure.
Yes.
Okay, very good. The number to call here is 313-769-6666, 519-256-1023. We have 15 minutes remaining and we are talking about bankruptcy. Questions, comments, we welcome your calls. Very good question Mr. Atiyah asked. A lot of people do not understand the difference between Chapter 7 and 13. Can I ask a very general question, and I don't know if you are able to answer it. What do people normally prefer? Do they prefer to file Chapter 7 or do they prefer to file Chapter 13? Or does it depend?
I have found most people seem to prefer to be in the shorter, cheaper process. That's Chapter 7, where you're
shorter is 6 months, in and out in 6 months.
In and out in 6 months. You keep your property, you get rid of your debts, as opposed to a 3 to 5 year repayment plan. So yeah, I always, when someone comes in, the first thing I look at is, are you a good candidate for a Chapter 7 bankruptcy?
So most people, all things being equal, prefer not to get involved in a 3 to 5 year repayment, prefer to wipe out their debts, keep their home, and be in and out of bankruptcy in 6 months.
Yes, that's what people prefer, all things being equal.
So what if I come to you and I say, I want to file for bankruptcy and I want to file for Chapter 7 because I want to be in and out and I don't want to repay money?
What I tell them
is it a question of preference?
A preference? Well, no.
Do you have to abide by my desires? I am the client, and I'm telling you, I want to be in and out, don't want to owe anybody money, do not want to repay people in 3 to 5 years, and want to keep my home. I want you, and I'm instructing you to file for me Chapter 7.
I'll evaluate them for the 4 main factors that determine whether or not you're a good fit for a Chapter 7. But for example, if somebody has filed a Chapter 7 bankruptcy 6 years ago, you can only file a Chapter 7 every 8 years.
Fine, that's an easy one.
Right. Another one is, can you protect all the equity in your real estate? There's only so much equity in your real estate you can protect.
In a Chapter 7.
That's correct.
So if I have a $300,000 home and I've already paid $200,000 and I insist on filing Chapter 7, can you protect the $200,000 in equity that I have paid already?
I will say if you have that much equity and you file a Chapter 7, the trustee is going to take your home. So I get that you want to be a 7, but if you have that much equity, way more than you can protect, that's not recommended.
So would I be safer filing Chapter 13?
Yes, no one's
Why
talking
is
about
that?
Because no one's talking about seizing assets in a Chapter 13. I mean,
okay. So one of the important factors is, yes, you want to be in and out. Yes, you don't want to repay people, but you are at risk of having your home being taken away, depending on the circumstances. But in a Chapter 13, yes, it's longer. Yes, you're repaying. But when you have a home with quite a bit of equity, you get to keep your home.
That's correct.
Pretty complicated.
Here's another factor too that's very common. Someone comes in and I want to do a Chapter 7. That's the only thing I want to do. But you look at the household income, you subtract out all the regular expenses, and they have $500 left at the end of the month. You may very well want to be a Chapter 7, but if you've got $500 left at the end of the month, you can go ahead and file a Chapter 7, but the court and the trustees are going to object all over that, and they're either going to dismiss the case or force you to convert to a Chapter 13.
Okay, so what you're also telling us is that even if somebody, upon the ill advice of a lawyer or whatever the case may be, files Chapter 7, the bankruptcy trustee can still object and get that case to be dismissed or force the person filing for bankruptcy to convert that to a Chapter 13.
Yes, there's actually 2 trustees in a Chapter 7 case. There's the one that you meet, the Chapter 7 standing trustee who actually questions you at the hearing and looks over all your assets. But there's also a U.S. trustee's office out of the U.S. Department of Justice that polices all of these files to see should someone be a Chapter 7 or are they abusing the Chapter 7 process and really should be a Chapter 13.
Okay, so there is something called loosely abuse of Chapter 7.
A presumption of abuse. If your numbers are too high at a certain point, it trips off the presumption of abuse. And then they look into whether or not you should be a Chapter 7.
Understood. We are talking with attorney Michael Bankstein, who heads the bankruptcy department in our office. The number to call here is 313-769-6666. 519-256-1023. We learned a lot of new things today, and one of them is that although a lot of people would prefer and like to file for Chapter 7 because 1, it is cheaper, 2, it is faster, you are in and out in 6 months, 3, you don't have to repay your debt to people you owe over 3 to 5 years. If you file for Chapter 7 and you really shouldn't have, it's very possible that the trustee in your case will get you to dismiss that Chapter 7 filing or will force you to convert it to a Chapter 13. So we learned about something new called presumption of abuse of Chapter 7 filing. Correct?
That's correct.
Okay. I want to talk very quickly about what it means to file bankruptcy, no matter what it is, Chapter 7, Chapter 13. There's something called an automatic stay, which means the minute you file for bankruptcy, if your house was in foreclosure, that stops. If a credit card was chasing you down and hounding you and creditors, that should stop. People who owe you, I cannot read lawsuit, okay?
That's my bad handwriting.
That's terrible handwriting, might I add. If you are in a lawsuit, there is an effect on that, and we'll talk about that in a minute. If anybody is chasing you saying, you owe me money, there is an automatic stay. A stay means a freeze, meaning everything stops. And everything stops for 6 months if you file Chapter 7, and everything stops for how long if you are in Chapter 13?
For the life of the case, 3 to 5 years.
3 to 5 years. Your credit card company to whom you owe $26,000 cannot talk to you. And those, what are they called? The people who hound you, the creditors?
The debt collectors.
The debt collectors, they're awful. They're awful. They're really awful. They stop at nothing. They call you at all hours of the day. So when you have a debt collector calling you and you want to put a stop to that, they should have known about it because you listed that debt. Typically, the debt collector is different than the entity to whom you owe the money. Let's say you owe the credit card company $10,000 and they send you to collection. You listed the credit card company as on your schedule as someone you owe money to. And technically, they're supposed to inform the debt collection agencies that you are in bankruptcy, but sometimes they don't. So what do you do to stop? And you've worked in consumer protection.
Yes, I've done some loss mitigation.
What can you do? You are in bankruptcy and they're still calling you. What can you do to stop that?
Well, one thing to prevent it in the first place is if you owe money to, the dentist or to the credit card company or what have you, and they've referred it to a collection agency, the best practice is to list the creditor and also list the organization collecting on their behalf.
To the extent that you know who they are. That's
Yes.
very good advice. So when you file for bankruptcy and you know you've already gone to collection, not only list the name of the original creditor, say the dentist, but also list the name of the debt collection agency that the dentist sent her or his bill to.
Yes, when in doubt, put them on the list.
Okay, what if you didn't know at that time or you forgot and they're still calling you? What can you do to stop them from calling?
Well, the thing that you should do when you find there's a creditor that that you didn't tell the bankruptcy attorney about, let your bankruptcy attorney know who that person is, and you can amend your schedules to list that person so they get notice of the bankruptcy, so they have to stop.
So you have a duty during the pendency of the bankruptcy, should you have forgotten some creditors or a creditor, to notify your attorney?
Yeah, you're required to list everyone that you owe money to. If you didn't remember, that's fine, but if you do remember, you want to list them.
Understood.
Now, there is a case where sometimes, hey, I forgot a creditor, not me, but
it can be innocently.
I don't mean me. I mean, the client just didn't think of, a particular creditor. If they're a general unsecured creditor, credit cards, medical bills, most of those kind of debts.
Let's clarify. A secured creditor would be somebody like, say, the bank holding your mortgage, they're not going to give you a mortgage unless they are certain that if you default, they have something in hand that they can use to repay that loan, so they keep the title of your home. That's called a secured creditor, because they made sure they gave you the money, they gave you the loan, they gave you the credit, but it's guaranteed by something. Versus a credit card company, they send you a credit card, and if you start using it, then it is a creditor. I think we have a caller. It is a creditor. And it's not secured because they're not using your car as collateral or anything like that. In the law, and without complicating it much, when you have a whole bunch of creditors and you don't know who to pay first, not you, but I mean in bankruptcy, the secured creditors take priority over the unsecured creditors. So your bank holding the note over your home takes priority over your credit card, takes priority over your landlord, takes priority over your possibly even car note if they recorded it before.
Yes.
And we have about 4 minutes remaining, and we take our last caller. Hello.
Hello.
How are you, sir?
Good. كيفك
يا أهلا وسهلا. ومع مين عم نحكي؟
نضال.
يا أهلا أستاذ نضال، اتفضل. عنا 3 دقايق.
إن شاء الله خير. أنا بعرف إنه الفيدرال لون ستودنت لون ما بيضمن البانكربسي، بس في أي حلول تانية؟
بعتذر، رجع أسأل سؤالك. ما في حدا بيتمنى البانكربسي، شو الحلول الأخرى؟
لا student federal loan بعرف
okay, government backed federal loans, student loans. Okay, very good.
في أي نعرف إنه ما بيروح بالبانكربسي بس.
Well, generally yes, student loans generally yes. So you're telling me that it's a government backed student loan? Okay, very good. سؤال من الأسئلة اللي كنا نقطة من النقاط اللي كنا حابين نحكي عنها اليوم. What is dischargeable and what's not. نحكي عنها من وقت لآخر. هيدا من هيدول الأسئلة وقت بيقدم الإنسان بانكربسي في كتير أشياء بتنمحى بينعفى عنها، وفي أشياء ما بيقدر ينعفى عنها. واحدة منهم هي الستودنت لونز. بس هون حسب من وين جاي الستودنت لون. Attorney Michael Bankstein, 2 minutes remaining. This gentleman, Mr. Nidal, has a government-backed student loan. If he files for bankruptcy, can it be wiped out? And if not, what other solutions does he have?
Well, one thing that student loans, federal student loans, they are generally not dischargeable in bankruptcy. So even though you can't discharge that in bankruptcy, though, their government loans, they're much more willing to work with you than private loans. So there may be deferments or forbearances available.
Deferments meaning postpone paying. What's the other term you use?
Or forbearance.
What is a forbearance? Meaning forgiving?
Well, no, forbearance means that they're not collecting, it's not late, but the interest is still running.
So what would you advise Mr. Nidal to do?
I would advise him to see, first of all, because a deferment's better than a forbearance, to see if there's to call up his lender and see if there's any deferments available.
Meaning if he can postpone paying, push it by another year or two so that he can get back on his feet.
Yes. Failing that, if there's no deferments,
will they talk to you? Will they talk to him?
Oh, they'll talk to him. There may or may not be some deferments left over depending on.
And
his
let's
program.
assume very quickly that they are not open to postponing payment or forbearing. What other options, if any, does he have?
Another excellent option, if there's no deferments or forbearances available, is you may qualify for an income-based repayment plan. I've definitely seen people on income-based repayment plans. I mean, precisely because you're heading into bankruptcy, you may have low income. You may qualify for an income-based repayment plan, and that can go all the way down to $0 a month for 12 months, subject to annual review, depending on your income level.
Okay, Estez Nidal, there appears to be perhaps a solution for you, even if you file for bankruptcy and you're still stuck with the federal student loans. If they don't agree to push it out, if they don't agree to forbear it, he is saying that another possibility will be what is called a repayment plan that's income-based, meaning based on your income. If he has any questions about this, because we did not discuss what that is, he should feel free to call the office and you will clarify to him what that is. Does
Oh,
he
yes.
normally need an attorney for that?
I would say initially, particularly if it's a government loan, which is much more willing to work with you, I would say call them up and ask them about it. They should be able to walk you through that. That's generally more cost effective than hiring somebody to do something that you could do, is to just ask them. Because based on your program that you're under, you'll either qualify for it or you won't.
Okay. Thank you very much Attorney مايكل بانكستين. بدي أذكر المستمعين عنا حلقة بكرة الساعة 3 إن الله راد. حلقة الجمعة بالإجمال بتكون تلخيص لكل المواضيع المهمة.